Good afternoon, and thank you very much for the opportunity to be here today and to speak before this honorable subcommittee. My name is Alan Grayson. I'm an attorney, and I represent whistleblowers in numerous cases involving fraud by government contractors in Iraq. At the moment, there are only 4 such cases in litigation that have been unsealed, and I'm attorney of record in all 4 of them. There are 3 of them against KBR. Needless to say, there have been far more than 4 instances of war profiteering in Iraq. Billions of dollars are missing and many billions more wasted. How it came to be that only 4 such cases are unsealed and in litigation, and how it is that even in those 4 cases the Bush administration is not participating, are the subject of my testimony today. As I'll explain, in our 5th year in the war in Iraq, the Bush administration has not litigated a single case against any war profiteer under the False Claims Act. For over a century, war profiteering cases have been brought under the Civil False Claims Act. This statute was enacted in 1863 to combat war profiteering during the Civil War. Lawyers often refer to that statute as the Lincoln Law. In 1986, when Congress enacted Congressman Berman's amendments to the Civil False Claims Act, it lauded the act as the government's primary litigative tool for combating fraud. And the Supreme Court has recognized the Civil False Claims Act as intended to reach all types of fraud without qualification that result in financial loss to the government. The Civil False Claims Act imposes treble damages and penalties on war profiteers, and the threat of having 3 times to pay 3 times what you steal can be a real deterrent if that threat is perceived as real. Moreover, the Civil False Claims Act deputizes whistleblowers to bring lawsuits in the name of the U.S. government against war profiteers. The whistleblowers can keep between 15 and 30% of the recovery, but with treble damages, the government ends up well ahead. The Civil False Claims Act yielded total recoveries of over $3 billion last year alone. But in Iraq, where there has been war and war profiteering for over 4 years, the total recovery to date is less than $6 million, in the midst of what Senator Dorgan rightly has called an orgy of greed by military contractors. Why has the Civil False Claims Act so far been unsuccessful in punishing and preventing war profiteering committed in Iraq, and what can be done to change that? One reason is that the Bush administration has swept cases under the rug by obtaining and perpetuating court orders sealing the cases. These orders allow the administration to threaten whistleblowers with dismissal of their cases or contempt of court simply for telling people what they know. To prevent the abuse of this sealing provision, which is only supposed to be in effect for 60 days, but in this case 60 days becomes 60 weeks and almost 60 months, there needs to be a firm limit on extensions of the seal. Clearly 1 year is enough. The seal is meant to help to uncover fraud, not to bury it. A second reason why the Civil False Claims Act has been unsuccessful in punishing and preventing war profiteering in Iraq is that after cases are unsealed, the courts create and apply rules to the cases that have no basis in the statute. For instance, the Act punishes anyone who knowingly makes, uses, or causes to be made or used a false record or statement to cause a false claim to be paid or approved by the government. Last year in our Custer Battles case, the first Iraq war profiteering case to go to trial, the jury found the defendants guilty of over 40 acts of fraud, but the judge suspended the verdict because he added a presentment requirement, a requirement that simply doesn't exist in the statute. Long ago, the U.S. Supreme Court said the court should refuse to accept any rigid, restrictive reading of the Civil False Claims Act, but that's exactly what's happening. Based on my experience, Congress needs to make the Supreme Court's wise words law by providing that the act shall be broadly and liberally construed in accordance with its remedial purpose. Other acts have that language, and this act needs it. Thanks to Congress, the Civil False Claims Act already makes it clear that a defendant's knowledge of the fraud is all that's required, not the specific intent of the fraud, and only a preponderance of the evidence of that is required. What is needed now is for Congress to provide that for a complaint under the Civil False Claims Act, only a short and plain statement of the claim showing that the pleader is entitled to relief is required. That's the normal standard under Federal Civil Rule 8A. It's the standard when a contractor sues the government, and it would be the standard when the government sues a contractor if the lower courts had not imposed a higher standard. Now, a third reason why the Civil False Claims Act has been unsuccessful in punishing and preventing war profiteering is that the Bush administration has done virtually nothing to pursue such cases, It settled 2 cases without litigation for pennies on the dollar, and it declined to prosecute 10 more. All the rest remain under seal. As I said before, in our 5th year of the war in Iraq, the Bush administration has not litigated a single case against any war profiteer under the False Claims Act. For all the Bush administration claims to do in the war on terrorism, it is a no-show in the war against war profiteers. Congress needs to fix that flaw by providing that the executive branch's see no evil, hear no evil, speak no evil policy regarding fraud perpetrated against the soldiers and the taxpayers in a war zone is no longer an option. I recommend that the False Claims Act be amended to provide that the administration shall participate in all war profiteering cases whenever the whistleblower complaint establishes a prima facie case of fraud. Both the troops and the taxpayers deserve no less. Fraud against the taxpayers is bad enough, but when that fraud is committed against the U.S. Army engaged in battle, it is intolerable. As Lincoln said 144 years ago, worse than traitors in arms are the men who pretend loyalty to the flag, feast and fatten on the fortunes of the nation, while patriotic blood is crimsoning the flames and their countrymen moldering in the dust. For 4 years, I fought the war profiteers who have been feasting and fattening on our misfortune. Let us acknowledge how far we have fallen from President Lincoln's standards and ideals and amend the Lincoln Law to remind this president and future presidents of their constitutional duty to see that the laws are faithfully executed. Thank you very much.